call will be comprised of 4 individual segments. The first being intergenerational transfers, followed by base year value transfers, followed by process and efforts to repeal. And finally, we are going to wrap up with additional questions received via the Q&A function at the bottom of your screens. Let's begin our segment by covering intergenerational transfers today. Assessor, this question, I'm going to field it to you. One of the most common questions that we've received in the planning process leading up to this town hall is, do I have to claim the homeowner's exemption to qualify for the parent to child and grandparent to grandchild transfer exclusion? Would you be able to clear that up for the audience?
Yes, it is mandatory that you file the homeowner's exemption. Homeowner's exemption is a very modest tax savings program available to anybody who owns and occupies their home, but it's taken on a whole new level of importance under Prop 19, because Prop 19 for the parent to child exclusion requires that the only property that your children may inherit from you along with your tax base is your primary residence. And the only way we know that that's your primary residence is if you as the parent have a homeowner's exemption, and upon your passing or your transfer to your children, that they file the homeowner's exemption. Though that is the enforcement mechanism that we need. Without that, the property will be reassessed to market value. It is a critical component.
Thank you for clearing that up, Assessor. And for those who don't know where they can apply for this exemption, where can they go?
On our website, there is a tab that talks about tax savings. One of those is the homeowner's exemption. It's a very simple form. We simply need your basic information. And unfortunately, it still requires a wet signature. It has to be mailed in. That will change probably in the next 24 months when we do it all digitally. But you just need to fill out that form and mail it in. It's not a complicated form at all. And you only need to do it once. They'll stay with you as long as you own the property.
Perfect. And just so our audience hears again, if you need to find that form, it is available on our website. So you can find it there, like the assessor said, with signature, and mail that into us. And Assessor Prang, I do want to continue on this theme with another question for you. Under Proposition 19, can multiple children inherit a single property and retain their parents' base year value?
They can. This is actually an interesting point, because it gives you a little bit of the window, our window into the things I was talking about, the ambiguities in Prop 19. So the way Prop 19 was written, it said that your children could inherit your property and the tax base. But as written, it would have required, if you had more children, it would have required all of them to live in the home, kind of an adult family reunification mandate. Obviously, that's not what they intended. That is what they wrote. The legislation, Senate Bill 539, corrected that. So now if let's say there's 4 children inheriting the parent's property, the law only requires that one of the children live in the property. It also allows all the children to decide at different times if a different one would live in the property. As long as there is a child who qualifies living in the property, the tax base can be transferred. It is important to note, though, that is in perpetuity. The moment a child is not living there, the property gets reassessed.
Great. Thank you for clearing that up for us. And Chairman Vasquez, I would like to direct our next question to you. Under Proposition 19, if a parent transfers one property to one child and another property to another child, can both children retain the parent's base year value?
No, no, only the one principal resident of the parent to qualify for eligible transferee who claims the ownership exemption can qualify for that.
Got it. Simple and easy. So now here we have a real life scenario submitted by one of our audience members. This scenario says, my mother held her property in an LLC. She recently passed away. Is the date of death transfer eligible for the Proposition 19 parent to child transfer exclusion? Rob, I am one of our special assistants from the office. I know we have you on this call. Would you be able to go ahead and clear that up for us?
Yeah, sure. Thanks, Ted. So in this particular case, the Proposition 19 parent-child transfer exclusion is not going to apply. The exclusion applies to transfers of real property interests between parents and children. However, it does not apply to transfers of legal entity interests between parents and children, even if those legal entity interests are also associated with real property.
Perfect. Thank you for helping us understand that, Rob. And I do want to wrap up this first segment covering intergenerational transfers with a question concerning property held in a trust. Assessor Prang, I'm going to actually direct this question to you. How does the Proposition 19 parent-to-child transfer provision affect property held in a trust?
So just to be clear, a trust is simply a set of instructions as to what is to happen with the property when the trustor dies or agrees for the point of transfer. So you're still obligated to take certain steps upon the death of a property owner, even if that property is in a trust. And if we're talking about a parent-to-child transfer, there are two minimum things that need to happen. That the trust is not autopilot. It doesn't do these things for you. You still are required to do them, even if the property is a trust. The first one is you are required within 150 days to file what's called a change in ownership, death of real property owner form. That tells us that the property has changed hands. Failure to file that in a timely manner could complicate estate planning considerations. The other one, if you're going to inherit the property under Proposition 19, you've got to fill out a Proposition 19 application. None of these things are automatic. We don't know what your individual family circumstances are and how that ownership works. If we don't have that information, we will perceive that as a transfer of real estate and the property will be reassessed. One of the things I want to emphasize on this point, though, is Proposition 19 has a very rigid implementation deadline. Everything needs to be done within 12 months. You need to file the death of real property owner form, the Proposition 19 form, and the children moving into the home have to file the homeowner's exemption. And it has to be done in 12 months. The previous law allowed, sometimes people didn't know what to do, they neglected it, they forgot about it. Sometimes several years could go by and we were oftentimes able to apply the tax benefits prospectively. Under Prop 19, it's a hard and fast 12-month rule. There is no discretion. If you don't do it in that period of time, the property gets reassessed.
And it looks like we have Sherman Vasquez who wants to go ahead and chime in. Did you have something to add, Sherman?
Yes, just one thing. There's a real good resource for those listeners, especially on this question about the trust. If you look at our website, we actually have under Property Tax Rule 462.160 gives you a more detailed explanation in case whoever asked this question isn't clear or has other questions about how to handle the trust situation in their property.
Perfect. Thank you. Thank you for those additional resources, Chairman. And before we move on to our next segment, I did want to put our Special Assistant Robbie Suzaki in the hot seat and have him clarify the homeowner's exemption filing deadline for us, just because I know that a lot of these deadlines introduced by Prop 19 have been very ambiguous, and I want to make sure that all of our attendees know when these deadlines are occurring and when they need to file by.
Sure. So as the assessor pointed out, one of the things that came into effect under Prop 19 is that very important one-year filing deadline for the homeowner's exemption claim after the transfer has occurred. Also, though, we have recently received some clarification on the filing of the claim. I believe the claim is still allowed to be filed within 3 years of the transfer date or before the transfer of the property to a third party. So it is a little bit more expansive than the one-year rule. Again, that's something that was recently clarified by the new legislation, but again, as the assessor pointed out, it's 1 year hard and fast rule for the homeowner's exemption claim.
Okay, thank you for that additional clarifying information, Rob. I know that our audience really appreciates it, but this does wrap up segment 1 concerning intergenerational transfers. Like